Hello, everyone, and welcome to the Expertise Unlocked podcast, a part of the Our Global, the largest international professional services network. I'm your host, Jennifer Riggins. Today, we're sitting down with Kelley Andrews-Edwards, partner at the Andrews Law Firm, and Thomas Pastore, managing director at Sanli Pastore Hill. Kelley brings the perspective of family law with complex custody and asset division cases in South Carolina, while Tom brings the perspective of forensic accounting and expert witnesses in California and all over. We're talking about jurisdiction disputes in family law and shareholder agreements, and really, it sounds like they have very different jobs, but a lot of this is around collaboration among professionals that can support each other, especially in these cross-border issues where not everything is black and white. So I would welcome you each, if you want to start, Kelley, and then Tom, to introduce yourselves first.
Hey there, thank you, Jennifer. So as Jennifer introduced me, Kelley Andrews-Edwards, and I am a partner at the Andrews Law Firm. I've been practicing family law exclusively for about 10 years. My kind of niche area in family law revolves around high conflict custody cases and complex asset division cases. And that's kind of where, my role overlaps with what Thomas does in terms of forensic accounting and business valuation.
Good morning, and thank you, Jennifer. I'm Tom Pastore, CEO and co-founder of Sanli Pastore Hill. So we're a business valuation and intangible asset appraisal firm. I've been doing this for 35 years with a specialty in family law valuations and forensic accounting, and I frequently work with family law attorneys like Kelley in my work.
Okay, and who would be interested in listening to this conversation we're about to have?
Ooh, anyone that has children, that's in a romantic relationship, especially a marriage, anyone that's potentially thinking about getting married and or divorced. The field of family law touches and is relevant, to almost everyone.
Yeah, and I would add, as far as professionals go, it would be the state and probate attorneys, immigration attorneys, intellectual property attorneys would benefit.
And then fellow forensic CPAs or people like that, state tax attorneys, different things, like anyone considering moving states as well. I think we talked about, as there's a lot of people that can listen to this, not always will benefit from it in the best circumstances of their lives, usually in a very stressful lives, but hopefully they'll be in good hands with your calmness and professionalism. So that's great. As this could be lawyers listening, or we said tax attorneys, things like that, or lay folks like me going through really some of the hardest part of their lives, like a divorce. Let's do a bit of vocabulary review to start us off on the same page. I know we had some terms, community property versus equitable division, if we want to start off defining that.
Tom, do you want to take the lead on kind of explaining what community property is? That's more in your ballpark.
Sure, because I do a lot of work in California and family law, and basically it's take all the assets, what are their values, and split it in the middle, okay? And that's basically community property, whereas equitable division, that's more in Kelley's work box. It's can be community property, but there are other things that she can talk about that affect it not being 50-50 split.
Yeah. Oh, please. Yeah.
So equitable division is the concept of identifying what assets and debts are marital, that are part of the marital pot or part of the marital estate. In South Carolina, where I practice, as opposed to dividing things straight off 50-50, the community property, the court has a presumption that a 50-50 split of the marital assets and debts is fair, is equitable. However, the parties do have the ability or the right to argue whether the estate should be divided unevenly based on their relative monetary and non-monetary contributions to the marriage. So it's not default 50-50 in every case. I've had cases where the marital estate's been split as far as 70-30 in some very kind of extreme scenarios. But for purposes of settlement, we often default and resolve cases unless they're outlying, pretty egregious facts, 50-50.
Yeah, because at first I thought, oh, that's interesting because we hadn't talked about debts before. And I was like, well, gambling addiction can be a reason to break up a marriage. And the person that's not with that addiction, while we acknowledge it's an addiction and that is a problem, like should not be saddled with this debt for the rest of their lives.
Yeah.
But
So in that case, if a party's conduct has unfairly diminished the value of the marital estate, that would be a factor the court would consider in deviating from a 50-50 split. Marital fault is one of many factors the court considers in dividing the marital estate. It often is not a huge factor. It really has to relate to a party's misconduct causing the depreciation and value of the assets of the marriage.
Mm-hmm. But on the other side, I could see it, especially women are more, and people of color are statistically like 4 times more likely to be caregivers and other unpaid work. And thus the law could harm them because they were not making an income while they were supporting the other partner's income.
So the court considers it kind of in response to that. The non-working spouse, let's say, their non-monetary contribution. So, as a homemaker, as a primary caretaker of the children, if the spouse at home was not there to watch the children, to provide all these other unpaid services, then the breadwinning or the working spouse would not have had the ability to earn that kind of income and acquire these assets. So the courts really do give value to those non-monetary contributions. And that's one of the reasons why there is a presumption of a 50-50 split. It's not to disentitle the non-working spouse of any of the marital property.
Okay, that's very interesting. What else should we know about, you've expressed to us before that like South Carolina is inherently quite unique. So
South Carolina, I think the most unique aspect in family law is I think there's one other state, only one of 2 states that requires either marital fault or that you be separated for an entire year in order to grant a divorce. There's no such thing as a divorce on irreconcilable differences. In South Carolina, you need to provide proof to the court that the spouse is engaged in some kind of marital misconduct, either adultery, physical cruelty, habitual drunkenness, or drugs and alcohol, or you have to show that you have been living separately apart from your spouse continuously for at least 1 year in order to get a divorce. The other kind of unique, I would say, aspect in family law that I've seen a lot of people who have relocated to South Carolina, especially after COVID for a warmer climate, that kind of catches them off guard, is that in South Carolina, if you commit adultery, even after you've separated from your spouse, but before you've reached an agreement or tried or received an order from the court resolving the issues related to your marriage, for example, support, you're statutorily barred from receiving spousal support, even if you're separated from your spouse. And I've seen that do a real injustice and a disservice to wives who had suffered horrible marriages, who separated from their spouse after separation, have gone on a date, and then they find out that they're no longer entitled to alimony. So that's a really important kind of point that I wish more people knew broadly, especially if you're relocating into South Carolina.
Oh,
And
wow.
I would
And
add I'm sorry.
that's shocking is all. No, please, Tom.
And I would add from a valuation standpoint in South Carolina that personal goodwill is not part of the community. Whereas in California, personal goodwill, it's at the discretion of the judge. It can be part of the community. So maybe if I gave an example of a dental practice that's doing, let's say, $500,000 in net income per year, from a valuation standpoint, if we were valuing this to sell the business, we'd probably use a multiple of about 5. Well, maybe about 6, but for family law purposes, you're often more conservative in California and in South Carolina. So that business could be worth 2.5 million. Now, if it has equipment of $60,000, that's the worth of the equipment, then the intangible assets are $2.44 million, okay? If that was all personal goodwill in South Carolina, you'd only be entitled to $60,000, the value of the fixtures and equipment. If there is an element, though, of business goodwill apart from personal goodwill, then my understanding, and Kelly, please correct me, is that business goodwill could be included in the property in the equitable division state. So if it was like $10,000, you'd add that to the $60,000, and that would be $70,000 to be split.
And what is goodwill in this situation?
Goodwill's reputation, patronage, location, the intangible asset value that drives the value of a business. For a professional practice, it's mostly the value of intangible assets like goodwill. That comprises the majority.
Like your patient base, if you're talking about the dentist.
Yes, it's your patient base, probably primarily, and then reputation, and can be location too.
Oh, okay.
So, I mean, that's what Tom brought up is a huge and very important difference because it can be a change from, going through divorce in California, where if you're a dentist, your dental practice could be worth $2.44 million, which is subject to the community property state and divided 50-50, or you could be going through a divorce in South Carolina where we're valuing the same dental practice and it's got an asset value of $60,000. And that's because in South Carolina, we differentiate between, and Tom touched on this, enterprise goodwill and personal goodwill. Personal goodwill is kind of the reputation, knowledge, and skill that stays with the individual. So if the individual left the business wouldn't be worth anything or anything more than it's just hard assets because the profitability came from that unique individual's contribution. Enterprise goodwill is, like Tom said, the intangible assets, of the business that survives kind of the business owner leaving. It still has value inherent to the business itself and not really within the person that was running it. So in South Carolina, service businesses, particularly professional practices, are almost entirely composed of personal goodwill. Like, for example, my law firm, if my two partners and I left the firm, it's not worth anything. The clients would have to find new attorneys if we all three just decided to close up shop. It's just worth, I don't know, what's in our bank accounts and what the computers are worth, et cetera, et cetera. And so dental practices, there's never been an appellate court case that has found enterprise goodwill in a dental practice in South Carolina. However, in mediations, I just mediated a case about a dental practice last week, and we do assign some enterprise goodwill to dental practices, at least in mediation at the trial level, because dental practices are bought and sold. Mm-hmm. There is intangible value to a dental practice absent that particular dentist performing work in the practice. And that's a very nuanced kind of exercise to go through. For example, this dental practice that I had a forensic accountant here in South Carolina value. We assigned it 20% enterprise goodwill. So you do like a marketability approach and then, 20% of that. So regardless, it's a much lower value than if Tom were performing the same business valuation in California. So depending on what side of the case you're on, that could be a good or a bad thing.
Mhm.
Yeah, and then if there's debt on the practice, let's say in the case of South Carolina and same dental practice, let's say there's debt of $60,000, that has to be deducted from the asset value, because what you're splitting up in the estate is the net equity value. So if you had $60,000 of debt, you'd have to deduct that from the total value for South Carolina purposes of 60,000. You'd be left with zero.
Mhm.
Whereas in California, you'd be left with $2.44 million to split up.
Oh, that's interesting, especially because it feels antiquated in this time of AI, but also we've been talking for at least 10 years, data is the new oil. I assume in a service-based business, especially in like a small town, the biggest value is your patient base in that situation. So, and if someone bought that practice, they would be buying it, and the agreement, I assume, would include access to the contact info or some sort of passing the way. Obviously, a patient could decide to leave if you mess up their teeth or something, but that would, I'm sure, part of an acquisition or merger process is that's the value more than, we all value a good dentist, but
there was to your point, our most recent appellate court opinion on literally the value of a dental practice in South Carolina was the husband was a dentist, had been, owner of his own practice for about 30 years, ties to the community with his patient base. He actually sold his dental practice during litigation, but before it got to trial for about like $600,000. Part of the sale was he had to execute a covenant not to compete. And so the appellate court, it went all the way up to our Supreme Court, looked at the different characteristics of his practice to see whether there was any enterprise goodwill. And one of the reasons there, his clients loved him because of who he was, that he was good at managing pain. He had ties in the community, advertised photos of himself. They found the entire dentist practice 100% personal goodwill. So even though he sold the practice for $600,000 during litigation,
oh no,
none of that was in the marital pot for division, which I was really shocked reading it because he sold the business. It was started during the marriage.
Asset, then it's a quantifiable asset.
But it was, the court found it to be all comprised of personal goodwill, which is not part of the marital estate, and therefore that $600,000 he received in the sale was not divided in equitable distribution. Very different from California.
Yeah.
Very different.
And then where do you come in this situation, Tom? So a dentist practice may or may not be very transparent in their work, but hopefully they are. But where are you bringing in your forensics, your research, et cetera, in a situation, especially when you talk about cross-state borders or these more troubling higher end marriages?
Oh, yeah. Well, I think you have to recognize what jurisdiction you're in. And then you've got to work with the law firms that are attorneys in that jurisdiction that are skilled like Kelley and knowledgeable, because in a family law situation, the attorney's always the captain of the ship. They are guiding that. We are assisting them and giving them vital information. But the first thing I have to know is, look, I'm an economist. I know how to value a business for a merger and an acquisition. But that can be drastically different in what the courts accept on a state-by-state basis. And so I have to rely on Kelley or her colleagues to show me, all right, here's what's the general rule. Here are the appellate court rulings. Here are the Supreme Court rulings. Because Kelley gave you just a perfect example of how something that, from a common sense standpoint, that $600,000 sale I would think should have been split up. In California, it would definitely be split up.
And then when you talk about that it's the Supreme Court of South Carolina, is it then precedent that all other cases will follow that suit, or is that just Supreme Court of
Yes.
the US?
Yes. So it's precedent. It does follow a long line of other opinions. Family law doesn't have the kind of, I think, the depth of case law that maybe other areas of law do. So, but within our case law, we have actually like a number of really good appellate court opinions about valuing business practices, because this is a very complex, important issue, and subject for dispute. Just the more complexity there is, the more areas there are to argue, and to poke holes at. And so we do these, so at least for right now, our precedent's pretty firm about professional practices being largely, if not wholly, comprised of personal goodwill, therefore of no value in the marital estate.
Wow. Even though that partner may have put off their
Now that's
work to
separate.
raise
Yeah.
Okay, that
That's
is
separate from like an asset value
Okay.
approach, where we're just valuing the tangible assets of the business. So sometimes there could be value to that. In the dental practice that I helped mediate about a week ago, she had, dental equipment, but it was over leveraged. So the business was worth zero, even doing an asset-based approach. But that's not to say that, there are plenty of businesses we hire people like Tom to value that do have, where we use the market approach, where there is a lot of value and we need skillful experts like Tom to help us do that.
And so when you're doing a divorce, it's based on the state you both reside in? Or what happens if people move during a divorce? Or maybe it could be based on the state you got married in sometimes, or no?
For South Carolina, it would be, there are a number of different ways you can establish jurisdiction. But, the state where the parties last resided as man and wife, is a way to establish jurisdiction. It's not so much where you got married, it's where you last lived together as man and wife. If you both relocated outside of the state, then it wouldn't have, any real personal or subject matter jurisdiction. You'd have to go if you wanted to file to where the defendant lived typically. But we look at where the parties last resided as man and wife. There are a lot of issues with jurisdiction about that, particularly when you get into child custody issues where, after cases are resolved, a party moves away. But it's not as difficult when you're initiating like the initial divorce action.
Okay, and we're meeting, well, y'all met each other through the IR Global Network, but there's this idea that there's so much information and there's often finance in other countries. You have financial assets in other countries. You may be traveling with children to other countries. People and families are just becoming more international, says the Jersey girl living in London, raising a half Spanish child. But you have this whole thing, if you have to depose a witness out of state, or not even, because in the US there's 50 different laws, or 51, I guess, or maybe more, because you have Puerto Rico and DC and all. So if you have to go through all those systems, what is some of the complexities that knowing each other, frankly, and trusting in each other works to help with that?
Yeah. So as an attorney that's representing the party who would hire, let's say, Tom as, our expert witness for financial purposes, it would be my obligation to find and provide him the financial information he needs to assess the marital estate, value a business, assess, income for support purposes, et cetera, et cetera. And we do that through discovery, which, because people are more global, they relocate across state borders, they relocate overseas, that is become a more complex process than it used to be. One thing, so for example, if I need to, the first thing I try to do is get the information I need from the other party. When that fails, or they're being difficult, or the marital estate is incredibly complex with lots of businesses and I need to get records from those businesses, then I have to subpoena third parties, let's say for financial information. If those third parties or third-party businesses are headquartered out of state and they don't have a process server in state, then I have to do what's called, I have to domesticate a subpoena. Same thing to get that information. Same thing as if I needed to depose a third-party witness that lived out of state. I'd have to domesticate a subpoena in the state and in the county where that business is located or that witness lives. Most states have adopted what's called like the Uniform Interstate Deposition and Discovery Act, which actually helps us streamline that. But a lot of times I can expedite that process by getting co-counsel, or there are third-party domestication services that I can use to try to reach out. I've gotten co-counsel. I've had to depose a witness in California before, so I've gotten co-counsel in California to help domesticate the subpoena, serve it on the witness, and to provide an office to conduct the deposition. If we're talking overseas, that becomes a little more complex. That, for example, the first thing I would do is go into the IR Global kind of membership portal and try to find a contact, an attorney that resides in the area where I need to kind of get discovery from. So it can be complex logistically, but IR Global is a great resource for finding people that can help expedite that process.
And I would add in particular that, excuse me, I'm sorry. I would add in particular that in those cases where we have a business that's not location specific, unlike a dentist, let's say it's fintech with international operations, I'd go to the IR Global database, or Kelly would go, and we'd probably hire a private investigator with international experience. And there are several, or even more than that, in IR Global, because they could help us perhaps find that second or third or fourth set of books that would portray the true financial situation of the working spouse's business.
And what happens if this information is found after a settlement is made, but then can you appeal divorce mediation results?
Not in South Carolina. So in South Carolina, when the family court approves a final agreement dividing marital property or issues an order after a trial dividing marital property, that is final. It's not modifiable. If you discover after the fact that, the other party lied and hid assets, there's a difference between intrinsic and extrinsic fraud, and I get them mixed up all the time. But one is basically you're lying through the discovery process, you're withholding information. That is not something, if you find out after the fact, you could use as grounds for an appeal or to modify. Now, the other kind of fraud, which might be, again, I always get intrinsic and extrinsic mixed up, but is where you actually commit fraud that disrupts the actual litigation process. Like this is an extreme example, but you hire someone to kidnap the forensic accountant from testifying in trial. Like that is not that that's ever happened, but that would be grounds for a modification, because the other party has engaged in conduct where they've interfered with the litigation process itself. From the court's perspective, well, he lied, but you had the ability to do depositions, to hire a PI, to engage in as much discovery as you want. You had your chance. You didn't find it. We're not opening this up again. Some ways I get around that, especially if you, in settlement negotiations, if you reach an agreement, we we have kind of a standard clause. I don't always put it in an agreement. Sometimes I do, depending on who I represent, but it's an undiscovered property clause. So which that way it kind of reserves the right through the agreement that if undiscovered property is discovered after the agreement is approved and made the court's final order, the court still maintains jurisdiction to divide it. But absent a clause like that, it's just over.
Well, that just sounds smart. So you may have given away your greatest power there on this podcast. Is there anything else you think that our listeners should know about and I should be asking about in this topic?
There's so much. I mean, I could sit here all day talking about the intricacies of family law, especially in South Carolina. But just, having a general awareness if you're relocating, kind of what the state law is, and just understanding that there are significant discrepancies between jurisdictions that really can materially affect your life if you do go down the road of a separation or divorce process.
Mm-hmm.
I agree.
Yeah, absolutely. If people listening want to get in touch with y'all to continue the conversation, ask some questions, what's the best way, Kelley?
So you can email me at Kelley, Kelley, at andrewslawfirm.com. I'd be happy to speak or answer anyone's questions.
Wow. Tom?
And for me, you could just Google Thomas Pastore space IR Global, and you get right to my page, and my email is right below my photo.
That's a great idea. And also, as you said, you use it as kind of a professional search engine in a way, but that kind of makes sense now. I understand more intrinsically why there is a vetting process and an interview application process to be part of the network so you can trust in people. But I do see a lot of these relationships like Kelley and Tom have. So thank you both very much. Just wanted to flag a couple other podcasts or episodes that I think those that are listening would be interested. Tenny and Amin and I recently talked about parental alienation and should that be a crime, and depending on which state, it almost is. So you can check out for that. And then also Tom and I've spoken before. You'll see the episode's called Dividing Assets, the intersection of forensic accounting, business valuation, and divorce. So you can find both those and tons of different resources and my conversations with folks like this, wherever you're listening to the podcast right now. Thank you so much to our listeners. If you know someone that can benefit from this conversation, and let's be honest, you might do, please do share it with them. That's the best way you can help friends, is by informing them. When they're going through this is a supportive thing, by informing them, by giving them access to reasonably trained people that know what they're talking about. Maybe they don't need your unsolicited advice. They just need your support. So please do tell people about it. And thank you both so much.
Thank you, Jennifer.
Thank you. Thank you, Jennifer.